Welcome back to Winning Isn't Easy. Let's first talk about Epstein-Barr disability insurance claims and what you need to know about limited disability benefit clauses. Now, many disability policies or plans have subjective medical condition limitations or limited disability benefit clauses. Generally, they will limit the payment of benefits to just 24 months. And there's really a fight often about the terms of these limited disability clauses and whether a particular medical condition actually falls within the limited disability benefit clause. And that's exactly what happened in the case of Tucker versus Express Scripts Health and Welfare Benefits. This is a case out of Missouri. Mr. Tucker was covered under a disability plan that had a limited disability benefit clause. It limited the payment of disability benefits to just 24 months for certain conditions, including chronic fatigue syndrome. Now, when faced with such a policy limitations, there are generally two arguments that we ERISA disability lawyers make. One, that the policy limitation is poorly written, and two, that the disabling condition isn't one of those limited benefit conditions. Now, in Tucker's case, the benefits for chronic fatigue syndrome were limited to just 24 months. The disability plan found that Tucker was disabled by chronic fatigue syndrome and then denied the claim for benefits in excess of the 2 years. Obviously, his case ends up in federal court. The I'm not disabled by chronic fatigue argument, I'm really disabled by post-viral chronic fatigue syndrome, fibromyalgia, and chronic Epstein-Barr infection gain. That's exactly what you try to do. You try to argue you're disabled based on medical conditions that aren't listed in that limited disability benefit clause. Now, that can be tricky because first, many disability policies or plans have a discretionary clause, and that discretionary clause, as you know, is a get out of jail free card for a disability carrier in a plan. The judge has to defer to the carrier or plan's interpretation of the terms of the policy and the terms limited disability benefits, unless it's unreasonable. And secondly, the judge is going to review the carrier's medical analysis and conclusions about what medical conditions are the cause of the disability and whether or not those medical conditions are excluded by that limited disability benefit clause. So in Tucker's case, he argued that his disabling diseases were the post-viral chronic fatigue syndrome, fibromyalgia, and chronic Epstein-Barr infection. He argued that Epstein-Barr was not one of the limited benefit conditions. But the plan had determined that he was disabled because of chronic fatigue and not the chronic EBV infection. Tucker's physician and the plan's physician relied on the same medical article about the relationship between CFS and Epstein-Barr, and they reached opposite conclusions about what it stood for. Under the ERISA case law, a disabling carrier or plan doesn't have to accept the opinion of a treating doctor over that of its own doctor. And so, of course, they did. And the court ultimately found it was not an abuse of discretion for the carrier to accept the opinions of its physicians and its physician's interpretation of the medical literature over that of Tucker's physician. And as a result, that denial was upheld. So regardless of the approach the disability policyholder or plan beneficiary is taking, you've got the burden of proof. And if you don't meet that burden of proof, you are going to lose. But I don't want you to give up. Disability carriers are in the business of denying disability insurance claims, and you shouldn't give up. But what you should be doing is working with an experienced ERISA disability attorney. Now, unfortunately, the facts are what the facts were, and Tucker's attorney worked with what he had. But I think that the fact that there is a strategy here that we ERISA lawyers employ should encourage you. Again, we start out by looking at the terms of the policy of the plan to see exactly what it says in terms of disabling medical condition. Is that diagnosis that our client has one of the conditions that is under the limited pay provision? And if it is, that condition goes out. We then ask, look, does our client have any other medical conditions that we could potentially argue are disabling? And we parse through those to see whether there are conditions, and if so, whether or not they are disabling, certainly consistent with the medical records. Then we're getting the physician involved to say, look, we want you to understand that chronic fatigue or Epstein-Barr are excluded conditions, but according to the records, our client has these other medical problems. Now, treating doctor, do you think any of these conditions would prevent our client from working or would provide restrictions and limitations that would prevent them from doing the material and substantial duties of their occupation. Yes. Well, good. Doctor, could you give me a report about the diagnosis, your opinion about restrictions and limitations, the objective basis of those restrictions and limitations, and comment on why you think the person might be disabled. And then, of course, that is information that the lawyer is going to be using in writing an appeal. They also may be taking the client to independent medical evaluation or a functional capacity evaluation to buttress the disabling nature of the non-excluded condition. And then ultimately, you want to be tying it together with a vocational opinion. So you can see it takes teamwork to get disability benefits and to make the right arguments or arguments that resonate potentially with the court so that you get the disability benefits you deserve. No lawyer can guarantee the results, but you can see the strategy. Got it? Let's take a break.